Welcome and aloha. I'm Mark Shklov, the host of ThinkTech Hawaii's Law Across the Sea program. Today we're staying in Hawaii, and my guest is Carl Varady. Carl is one of the attorneys representing the plaintiffs in Kalima versus State of Hawaii, a case that has been in the news recently, although it was filed over 20 years ago. Kalima versus State of Hawaii was filed on December 29th, 1999. We think we have a screenshot of the first page of the complaint. There we go. On June 30th, 2020, the Hawaii Supreme Court rendered a definitive decision in favor of Native Hawaiian rights in the Kalima case. We got a screenshot of the Supreme Court decision, first page, showing the dates. I think it's important to take a look at those dates. And I've asked Carl to provide us with a basic understanding of the Kalima case and the recent Hawaii Supreme Court decision. He's been involved in the case since it was filed. Aloha, Carl. Good to see you.
Aloha, Mark. Thanks for having me and giving us an opportunity to chat about this important case.
Okay. Yeah, and we've heard about it. It's been in the news, but tell me, what was the Kalima case about?
Well, the Kalima case is the case brought by 2,721 Native Hawaiian claimants who filed administrative claims with something called the Hawaiian Claims Panel in the period of 1991 through 1995. That claims panel, as you may recall, was created to address the fact that everyone agreed there had been numerous violations and breaches of trust occurring between 1960 and 1988 in the administration of the trust, many of them contributing to the lengthy waiting lists. In 1988, the state waived sovereign immunity and allowed Native Hawaiians to sue the state for those breaches of trust occurring after 1988. As part of that bill, the legislature gave the governor 2 years to come back with a proposal for the people who experienced breaches of trust in the period of statehood from 60 to 88. This statute was intended to address particularly the waiting list claims and give people an opportunity to go into an administrative process that was intended to be informal, collaborative, and investigative in the sense that the claims office had actual investigators who would investigate the claims and help present them to the panel. The panel, who were appointed by the governor, would then make recommendations to the legislature that could be funded to resolve these claims. None of those resolutions was ever funded, and in 1997, the panel sunsetted because its funding was not renewed. And what that meant was the 2,721 claimants who had come in the front door had no means of resolving their claims except to sue. This lawsuit followed that, and that is exercise the right to sue in circuit court for resolution, primarily of waiting list claims, but other breaches of trust as well.
Okay, when you say waiting list claims, and they're on the waiting list to get property. Is that what the Hawaiian Homelands Trust was created for? Was that what that was about? That providing Hawaiian land for Native Hawaiian people?
That is correct. As a condition of statehood, Hawaii accepted possession of the Hawaiian Homelands Trust. And as a condition of statehood, they took over as principal trustee, administering the trust for the benefit of Native Hawaiian beneficiaries. That's people of 50% or more Native Hawaiian ancestry above the age of 18 who can receive the benefits of homesteading, which is a form of economic rehabilitation, because obviously if you're paying $1 a year for the ground on which your house sits, you're way ahead of your neighbor who's having to pay market values. Now, even though as a condition of statehood, Hawaii was required to accept that obligation to administer the trust as any other trustee would, including any of the major banks, trust companies, other financial institutions, the state of Hawaii never funded the Homelands Trust And as a result, what happened was they could not develop the properties that they had. It was underfunded for decades. It was not until 1985 that the Homelands Trust itself could produce a set of auditable financial records. Think about that. Over 200,000 acres of land, and they can't be audited. If you don't have auditable records and you don't know what your revenues are for things like water, access, or other leasing concerns, how can you possibly exercise your bonding authority? So it was a crippled, hobbled agency from the very beginning. The state of Hawaii did not uh, appropriate general funds until after 1985. So for that first 25 years of statehood, what you had were a bunch of people applying for land that the department could not develop and which everyone knew they could not develop consistent with demand.
So you had a law that the state was agreed to be the trustee to provide land to Native Hawaiians, but they never did it. And the only option left, it sounds like, after many, many years, was to file a suit, a lawsuit. And that's what the Kalima case was about. Is that right?
It is a limited suit for people who were able to get in the front door of that administrative proceeding that I told you about. Now that's 2,721 people. I believe today there are over 28,000 people waiting for homestead awards. Now, mind you,
Oh.
the department was not created to make lists and maintain waiting lists. It was created to develop land, to put Native Hawaiians on that land and provide them with economic rehabilitation. That's been its purpose since 1921, and it's never been taken seriously. And certainly during the time period between statehood and now, no one can argue that it has done it effectively or consistently with the highest duty, which is the duty of a fiduciary, as you well know, that applies to any trustee administering trust property. In fact, in 1993, a survey showed that not only had lands been given away both to the local, state, and federal governments, about 18,000 acres, 16,000 or more acres could not be accounted for in the land inventory. Now imagine if you were a large landowner and were having a large financial institution administer your property, and you went down there and they said, well, you know, we can't find these 16,000 acres. What would happen then? So we're not here, and I want to make this really clear. This case is not about rehabilitating the trust or the administration of the trust. It is only now to get what the statute provided. And in the end, what the statute provided and what the Supreme Court said the beneficiaries here would receive is financial compensation that's equivalent to what they lost. That is the fair market rental value that they were forced to pay out of pocket for a developed piece of land on which you could build, as compared to the dollar a year they would pay had they been given a homestead, which is what the program is supposed to provide.
Okay, now, who were the parties in this case? I mean, we call it the Kalima case. I know this was a class action, and you mentioned about 2,700 people. I guess those are the claimants. But who are the named representatives when you filed the case, and who are the defendants that that were sued?
Well, the only real defendant is the state of Hawaii, because its political subdivisions aren't recognized as separate entities, at least not the Department of Hawaiian Homelands. There may be some quasi-governmental entities out there that I'm not thinking of right now, but the department is simply an arm of the state. So the true defendant is the state of Hawaii, which again, remember, in order to become the 50th state, Hawaii made a solemn promise to accept and administer these trust lands for the benefit of these beneficiaries as any other trustee would. They haven't done that. The plaintiffs, the named plaintiffs, um, several of them have changed. For example, Joseph Ching died during the period of this lawsuit. Mr. Ching just was the embodiment of aloha. When I was at Native Hawaiian Legal Corporation as a staff attorney there, I actually represented him in the administrative process I was telling you about. Just a wonderful man. Just you felt his warmth and his genuine aloha anytime you were with him. His daughter Raynette now has taken his place. Leona Kalima is the lead named plaintiff. She lives in Waimanalo. She finally was able to obtain co-ownership, actually, of a trust lot over there. And uh, Diane Boner is an original plaintiff who's been with us since the beginning. Again, she finally got, I think, sometime earlier this decade, finally got a homestead award. But she still was delayed, and that is what the case is about. It is we don't have a Department of Hawaiian Homelands to maintain a waiting list. We have them to develop and present leasable, inhabitable lots to the beneficiaries. Diane's one of the many people who waited on the land. Vehi Ching, who happens to be Joe Ching's widow, another person who went in to apply in the 70s, was told, "Oh, you're married. Your husband applied. You can't apply." Uh, Uncle Jimmy Akiona from the Big Island came over and testified for us. He was one of our testifying plaintiffs at the liability trial in 2009. He's passed. Uh, Uncle Sonny Kaniho, he's passed. 400 or so plaintiffs, by our best estimate, have passed since the beginning of the lawsuit. And to their credit, many of their heirs and successors in the past 2 weeks have been calling us to find out what the status is and how they can continue to pursue, both as a matter of right and as a matter of honor, these important claims.
And the named representatives in the original complaint, they are representative plaintiffs as well as in their own individual right. So they're standing up for all the Native Hawaiians that made the claims. Is that right?
That's right. For example, Caroline Bright also has passed. She represents very much what happened with a lot of homesteaders. She was forced at one point actually to live just in destitution and poverty, and went down to beg for a homestead and was told, cannot, sorry, there's nothing available. And she testified at trial. She stuck with us the whole way, and she is now passed. Irene Cordero Vieira, she had lived on the Big Island in a house with no running water or electricity for a period of time. And again, a person seeking a homestead who finally got one after decades, but there's simply no excuse for why people have to wait decades to get something that is their right by birth.
And I want to ask, after we take a minute break, I want to ask what this Hawaii Supreme Court said about the obligation of the state to provide lands and compensation if there were no lands provided. So we'll take a break and be right back with Carl Varady. Thanks, Carl.
Thank you.
Aloha, we're back with Carl Varady, one of the attorneys for the plaintiffs in the Kalima case. And Carl has set the stage for what comes next. And we talked about the fact that the state of Hawaii had an obligation to provide lands to Native Hawaiians, not a waiting list, in Carl's words. And over 20 years ago, Carl and his co-counsel filed an action to get compensation, as I understand it, from the state. What did the Supreme Court of Hawaii say, Carl? What was their decision in this case on June 30th of this year?
Well, it was really twofold, Mark. In the first place, we were up on the original liability trial, which occurred in 2009, in which it was found that the state had violated fiduciary duties, breached trust in a number of ways, and also that breach proximately caused damages. As you know, that's a required piece of proof. In order to obtain damages, you have to show that not only did they breach something, but it was causative of the damages that the beneficiaries experienced. And what the court said was sweeping, and a sweeping affirmation of what the court below said. And they said it's undisputed that the state breached its duties to keep accounts, exercise reasonable care and skill to administer the trust, and to make the trust productive, to the significant detriment of the Native Hawaiian people for whom the trust was created. Now, an interesting thing that the court also pointed out, and it did so more than once in its opinion, was that the state's decision to continue to litigate this case for decades compounded these breaches of trust and the challenges that the claimants faced in now proving their damages. Because remember, at the time these claims were filed, in some cases, it's say you filed in 1991, well, you might have a claim going back to 1971. It's 20 years old at that time, right? Now, how old is it, right? So the court was very aware of the fact that 2 more decades had elapsed, and that it was going to be very difficult, if not impossible, for people to say, "Oh, I stay with my auntie. I paid this amount." And the court said that's not required. This is a class case, and that brings us to the second prong of the court's decision. Was not only did it rule in our favor on liability and damages, a cause of damages in the way that I've expressed, but it found that damages could be measured on a class-wide basis using a Miley lot as an exemplar of what a residential homestead, a residential developable lot would be over the period from 1960 to current. And by doing that, it alleviated the need for people to come in with, boxes or bags full of receipts and the like from 20, 30, or 40 years ago, which would be manifestly unfair, especially in light of the breaches of trust. And that's what the court kept pointing to: is this is a problem that you created, state of Hawaii. You can't profit from your breaches of trust by saying, "Oh, we can't find your records," or "We don't know about this," or "Sorry, it's been a delay. We don't know what happened to you." You're not obligated to prove that. You're obligated only to prove that you applied in a particular year, and you either got an award or did not get an award, and your damages will be measured on fair market rental value for a residential lot during that period of time.
The Supreme Court's decision is, to me, as a lawyer, a serious, I use the word indictment, but of the state of Hawaii for failure to act properly, and especially on behalf of Native Hawaiians. And I noticed when you filed this lawsuit, you'd also written to the state of Hawaii a letter by co-counsel in this case, asking for remedial action. And did anything come of that? I mean, did did the state ever try to come forward or to resolve this matter as requested?
The short answer to that is no. The state had every opportunity in the first instance to make it a simple process that would allow people to come in and, as I said, represent themselves. Governor Waihee testified he expected it to be something uh, even simpler than workers' comp, where you simply say, here's what I had to spend, here's what I lost, um, and this is what I'm seeking in compensation for not having a homestead during that time. Uh, the uh, the state turned it into a massive litigation and compounded the original breaches of trust really by pounding people who don't have means or resources to fight, uh, you know, to abandon their claims. And I think I misspoke earlier. I believe I said that the process sunset in 97. I believe the correct date is 1999. It doesn't matter. It's the front door shut down in 97, and then the panel was not funded uh, and concluded its work in 1999. So the uh, uh, the process was made all the more difficult by 20 years of litigation.
I mean, do you have any? Have you? I mean, to me, this would be a sleepless night. I mean, why are they doing this? Why have you reached any reasonable conclusion or understanding of why the state wouldn't just act in a pono fashion, as we would say, or do the right thing? Why drag this case on? What's have you do you understand that, or do you know that? Did anybody ever explain that to you from the state?
No, in a word. And I think it's inexcusable. Any trustee, think about it for just a minute. Any trustee, bank, mortgage company, uh, a trust company, large financial institution, managing 200,000 acres for a private beneficiary to litigate for 20 years when it's indisputable, or as the court said, excuse me, undeniable, that these breaches of trust occurred with the kinds of things I told you about. No auditable records for the first 25 years from statehood to 1985. I mean, that tells the whole story right there. I have no explanation. I think those questions are better put to the people who've made the decisions to continue this litigation. I will tell you that every administration from after Governor Waihee's, every administration and every attorney general from then until now has fought this case, and that hasn't changed. So um, I think it's uh, a vain attempt to avoid the consequences of the truly crippling method by which this trust was administered over the period of time from statehood till now. And I don't have an explanation beyond that. It's denial.
And it looks like the Hawaii Supreme Court agrees with you, uh, in their opinion. I mean, I read the opinion, and I mean, there's no excuse.
Right. When the court says it's undeniable that these breaches of trust occurred, that is a very rare statement in a civil matter, as you well know, for there to be no doubt that these things occurred, and no doubt that by dragging out the litigation for 20 years, and really the administrative process for 10 years before, 8 or 9 years before that, is inexcusable. It's just inexcusable, and I think there is no valid explanation for it beyond just vanity and expecting at some point in time the beneficiaries to go away for whatever reason.
Well, where do we go from here? Where does the case go from here? What do beneficiaries need to do? Those that, I mean, and those that are the heirs of beneficiaries, because as you mentioned, a number of them have, passed away. So where do you go from here? What's the next step in this case?
Okay, well, those are two separate questions. I mean, for any heir of someone who is a claimant in our case, who's listening to this broadcast, they should consult with uh, some law firm or attorney knowledgeable in trust and estates, and make sure that they're capable of representing the estate of the claimant who died. In terms of what happens on the remand, as you recall from reading the case, in the remand order, the court, sorry, in the opinion, the court acknowledged the claims administration order, and that will be a process that will be put into place once we go back down. Claims administration means a special master will be assessing the damages for each of the claimants under the rubric of this case, under the method that was adopted, the fair market rental value. And a claims administrator will then ultimately pay out the claims once the court approves them as final. Now, that's still going to take some time. There will still be cases with wrinkles beyond just mere waiting list claims. But for a large chunk of these claimants, they will get some relief through the special master and claims administration process. And as you know, I'm just by way of explanation for anyone who doesn't, however, the special master is like an assistant judge who will make findings and recommendations. Those will ultimately go to the judge, and the judge will review and approve, revise, or remand them back to the special master for further proceedings. That's how we expect it to go. But I think there'll be a big chunk of people who go through with the application dates that are undisputed, award dates that are undisputed, if any, and finally be compensated for the breaches of trust. I mean, one of the nice things that happened in this case, Mark, is that the trial court judge had given them six years credit against damages, saying, "Well, you get 6 years." There was no evidence in the record to support that. The Supreme Court said, "No, there's no 6-year grace period. Sorry." So the claimants now get 6 years of damages restored, and that's that with the fair market rental value measure should really uh, make the process much less cumbersome to wind down and complete than when we went up with the 21 different defenses that the state had concocted that the Supreme Court was just not hearing.
Carl, we have 1 minute left. What have you learned from this case about life and law? What can you say to
I'm
our
just,
audience?
Mark, I'm just really grateful for the commitment of our clients to stick with us and understand that it's a lengthy process with 99 twists and turns. Occasionally, you get to a vista where you can see justice. We were able to get to that vista in this case, and I'm just grateful that the Supreme Court heard and understood what this case was about and made absolutely unequivocal pronouncements about what happened, what was wrong, and what should happen next.
Well, Carl, I look forward to talking with you again about this case, seeing what ultimately comes of it. And it sounds like the right thing was done. It sounds like the motto of our state. The life of the land is preserved in righteousness. Wow. And I congratulate you on this. And thank you very much for your hard work. Aloha, Carl.
Aloha to you, Mark. I appreciate it. Also want to mention Tom Grandy is my co-counsel throughout this from start to finish.
All right. Yeah. So sound like a good team you had together.
We had a very good team, and as I said, we're just grateful for the clients and for the court really hearing us in a deep way.
All right. Well, that concludes our discussion of the Kalima case today, and hopefully the right thing will continue to be happening in the state of Hawaii from now on. Aloha.